So before I move to the appeal process, we were looking at the guidance in relation to the application forms. Once the application form was received by the Skipton Fund, in some cases, if the fund administrator thought that further information was required, the form would be returned either to the applicant or the completing clinician. And once the form was completed to a level which seemed to the administrator, as far as we can tell, to contain adequate information for the purpose of making the decision, a decision on eligibility would be taken by the administrator, so by Mr. Foster and then by Mr. Fish, but would require, as it were, a sign-off from one of the directors. And again, no doubt Mr. Fish will be able to tell us a little more about how that works in practice when he gives evidence tomorrow. Then in terms of appeal, if we go to, just find the reference, SKIP 5030_023. We'll see there that the Skipton Fund Appeal Panel members were appointed by the NHS Appointments Commission. I think the written note suggests that the appointment was made by the Department of Health. It's actually by the Appointments Commission, but the Appointments Commission was an arm's length public body of the Department of Health, so associated with the Department of Health. And we can see that the appointments were finally made with effect from the 1st of September 2006. We look down the bottom of the page, we can see the terms of reference of the appeal panel. The role of the appeal panel is to reconsider the cases of any claimants who appeal against individual decisions made by the Skipton Fund. The panel will look at how the decision was reached and examine all available evidence, or seek further written evidence where necessary in order to either confirm or change the Skipton Fund's decision. In considering the evidence, the appeal panel will look solely at the written evidence and will not seek personal attendance. The panel will not be able to consider appeals against the ex gratia payment scheme itself, but only to examine the process to determine the claims within the terms of the scheme. And then appeals could be made against both Stage 1 and Stage 2 payment decisions. If we go over the page, we can see the details of the appeal panel members. So the chair was Professor Mildred, who we're hearing from this week. If we look down the page, we'll see there was a lay member, there was a hepatology member, and then if we go to the bottom of the page, a haematologist, Dr. Patricia Hewitt from the NHS Blood and Transport, and then over the page also a GP. In terms of the appeal panel guidance notes provided to applicants whose claims had been rejected, we can see those at NHBT 0090738. These guidance notes are not dated, so it's not clear at what point in the appeal panel's life they began to be provided to applicants. But we can see at the top of the page, the following notes are for your guidance to help you provide the information that the appeal panel is likely to need in order to fully consider your appeal. And then the next paragraph refers to balance of probabilities. The last sentence of that paragraph, it has to have been a probability and not just a possibility that your infection with hepatitis C occurred in this way. And then we can see there's a discussion of missing records. The most common reason for an initial refusal by the fund is the absence of documented records of eligible exposure. This may be because the records exist but do not mention a transfusion or other exposure, or the records are lost or destroyed. Paragraph 2 suggests the applicant make every attempt to obtain and produce as much as they can by way of hospital records. Paragraph 3 suggests that they ask the GP to look back through GP records. Paragraph 4, if records are not available, obtain and produce a letter to that effect from the Hospital Records Department and or GP. Paragraph 5, provide a personal statement for the appeals panel, giving in as much detail as you can what operation, procedure, accident or illness led to the procedure, when it occurred, and why, in your recollection, a transfusion or other exposure was needed or occurred. 6, if you have any witnesses to the alleged exposure, for example, relatives or hospital visitors, you should get a statement from them and include it with your appeal. With any written evidence of the treatment you believe led to your infection, please provide a photograph of your operation or injury scar. And then 8, in the absence of complete records, the panel will make a judgment on the likelihood of your exposure to hepatitis C given the type of treatment, the circumstances, and the outcome that you describe. So the appeal panel looked at a wider range of evidence than the initial application process permitted or contemplated. How the appeal panel then dealt with that wider range of evidence, we'll have a look at some examples and we'll no doubt wish to explore with Professor Mildred. Why it was that the same invitation was not issued to applicants at the outset is unclear, because of course there may have been applicants who could have provided personal statements, witness testimony and the like at the first stage, didn't because there was no opportunity for them to do so, and effectively then gave up. It would only be through going through the appeal process that you would receive these notes suggesting that a wider range of evidence be considered. And as I say, it's not clear why that approach was taken. If we go over the page, intravenous drug use, applicants who've had a history of exposure to recreational intravenous drug use such as heroin are unlikely to succeed in their appeal. This is because expert advice shows that the chance of getting hepatitis C from even the smallest degree of IVDU is many times greater than the risk of getting hepatitis C from a transfusion. However, because the panel considers each case individually, you should document all your intravenous drug use in as much detail as you can. The panel will make a judgment on the relative likelihood of your having obtained hepatitis C from intravenous drug usage or from NHS treatment. And we'll look at what the expert advice was in a few minutes. Other risk factors. So we'll see that the panel asks applicants to identify other factors that might have contributed to the risk of infection. Tattoos, other recreational drug use, including snorting cocaine. Quite why that's thought to be relevant is unclear. Sexual activity involving the exchange of bodily fluids with a person infected with hepatitis C. And then other reasons for refusal, and then there are set out a number of potential other reasons for refusal. One is the cut-off date of September 1991. Another example is at C is treatment abroad. D, discrepancies in the application form. E, natural clearance. And if we go to the next page, we can see paragraph 4. So this is the advice given to those appealing. Obtain a copy of your original application form, and we've seen the process didn't provide for the applicant to have that, so they've got to make the effort to get that. And make sure you agree with what's been said. And then paragraph 5 deals with the position of natural clearance in some detail. And then bottom of the page, please note the appeals panel doesn't have any power to consider cases that fall outside the Skipton Fund scheme. Applicants were not able to make representations in person, as I've indicated. And it appears from the inquiry's investigations that the panel's view was that it didn't have the power to do so. But the basis for that can no doubt be explored with Professor Mildred. The inquiry's analysis so far of the information it's received in terms of applications and what happened to them suggests that the appeal panel overturned 49.6% of the rejections that were referred to it. We can take that down, thank you. In terms of the burden and standard of proof, we've seen that the burden was regarded as being on the applicant. The standard of proof was expressed to be on the balance of probabilities. There is some evidence, which I'll be exploring with Mr. Fish tomorrow, to suggest that additional measures put in place following the discovery that the scheme administrator had defrauded the Skipton Fund may have led to a stricter approach to applications It became, for example, a requirement that a copy of medical records should be provided to the Skipton Fund. As I say, we'll look at some documentation relating to that with Mr. Fish tomorrow. There is evidence to suggest that in turn caused, or might have caused, financial difficulties for individual applicants. You will recall, sir, during the evidence of Dr. Giangrandi that we explored the charge that was imposed by the Oxford University Hospitals NHS Foundation Trust for completing the Stage 2 forms, and we've seen in various documents, or the inquiry has seen in various documents, potential costs to the applicant in trying to get copies of medical records. They would be charged for that. Just to complete the picture in relation to what happened in Oxford, if we go to WITN 5573001, please. The inquiry following the evidence of Dr. Giangrandi asked the Oxford University Hospitals NHS Foundation Trust to explain why charges were imposed for the completion of the Stage 2 application forms, and received a statement from Dr. Susie Shapiro on behalf of the Trust. And if we go to the second page, we pick it up in paragraph 5. She did not have any information beyond that stated in the letter from Dr. Giangrandi to the Skipton Fund, which we looked at during his evidence. And then if we go to the bottom of the page, the inquiry asked if the fee was levied against patients directly, and she answers, it appears from the records that the fee was levied against patients or patients' relatives directly. And then if we go to the next page, paragraph 8, you can see she was asked about whether other forms were charged for, and the Trust had found no evidence of a separate fee being charged by clinicians for completion of other forms, but she recorded that the Trust had historically charged for photocopying medical records centrally, and that appears to have been the position until July 2017, according to paragraph 8. And then if we go over the page, paragraph 12, she says the Trust wishes to apologise that patients were charged for the completion of Skipton forms. As this is not representative of the supportive approach that we strive for, the Trust is taking steps to refund the relatives of patients for any fee incurred for completion of the Skipton Fund forms. So I mention that because we set the hair running, as it were, during the evidence of Dr. Giangrandi, and those familiar with that evidence may have wished to know what happened in terms of the inquiry's further investigation of that issue. The extent to which that was a course taken by other trusts is currently unclear, but certainly applicants to Skipton having to pay for copies of records is highly likely to have occurred across the country.
Well, the hurdles in terms of making an application and then making an appeal would be these, if it's a hurdle, in the first place, knowing that there is the Skipton Fund. You've shown me this morning considerable detail in a document plainly intended to be read by a patient rather than a doctor, and intended to inform them about Skipton. But how did they know where to go to get that document? And how did they get hold of it?
Yeah, well, those are documents, I think, that were made available by the Skipton Fund to those who had some knowledge of the Skipton Fund and therefore knew to make some form of contact. In terms of what steps were taken by the Skipton Fund to promote its existence, that's a question we're going to need to ask Mr. Fish tomorrow.
So we have no documents about that?
There are no documents that I can call to mind immediately, at least, that tell us the answer to that. And it's a question we'll also want to direct to the Department of Health, because, of course, the Skipton Fund was the agent of the Department of Health, delivering services on its behalf. So there's a bigger question of what steps were taken by the Department of Health, or indeed the health departments of the devolved administrations, to, as it were, broadcast or advertise the existence of the Skipton Fund more widely. And we do know, again, this is something Mr. Fish may be able to assist with, but we know applications continue to be received by the Skipton Fund throughout its life. So applications were still being made in 2016, 2017, in circumstances where obviously the infection had to have occurred before September 1991. So some of those may, of course, be the result of the diagnosis of hepatitis C itself only being made at a later stage, but some may be due to a lack of knowledge about the Skipton Fund.
The knowledge about appeal would seem to depend upon the individual first deciding that they wanted to appeal, or at least investigate the possibility of it, and either contacting Skipton or obtaining it through their doctor.
Again, Mr. Fish may be able to assist, but it looks from the refusal letters that we've seen, it looks as though it was routine in the refusal letters to refer to the right of appeal.
But to include the document or not? The guidance notes? The document itself suggests that it should have been sent routinely. Whether as a matter of fact it was, I think we'll have to wait until we hear from Mr. Fish tomorrow. Yes, thank you.
So we can take that statement down, thank you. So the inquiry has been analysing hard copy applicant files held by the Skipton Fund, with, I hope for obvious reasons, a focus upon applications which were rejected at the first stage, to examine the decision-making process in that regard. And so the inquiry requested from Russell Cook solicitors, who effectively administer what's left of the Skipton Fund. It's no longer operational in terms of decision-making. Copies of all Skipton Fund files relating to applicants whose application was declined or repealed. And it's become apparent to the inquiry on reviewing the material that not all applicant files still exist, and that of those they do, many are incomplete. Some don't even have a completed application form. The inquiry is making further inquiries as to why that is the case. If we could have up on screen, Shamik, our written note about the inquiry's analysis of these files. It's INQY 40245, I think. And if we go to page 15, we can see some statistics. So we've got a classifications declined, application unsuccessful either at the first stage or on appeal, unresolved applications in respect of which there was a registered application, but the fund considered there wasn't a sufficiently complete application form for the purpose of making a decision, and then approved either at the first stage or on appeal. So those are the terms that are used. And then under the heading statistics, we've got some hard data. This is taken from a spreadsheet that's been provided to the inquiry by the Skipton Fund. 6,712 applications, 338 unresolved, 5,529 approved. Of those, 5,309 approved by the Skipton Fund itself, 220 declined by the Skipton Fund but then approved by the appeal panel. And then total applications declined 845. We go over the page. Number of applications declined by the Skipton Fund where no appeal was heard, 622. So that's the number that didn't proceed to an appeal. number of applications declined by the Skipton Fund, and that refusal is upheld by the Skipton Fund Appeal Panel 223. Total applications reviewed by the Appeal Panel 443, and then applications submitted on behalf of a deceased infected person 785. So that gives some parameters in terms of the work that was undertaken by the Skipton Fund and the Appeal Panel. Could we go to page 19, please, Shomik? You'll see there, sir, a table set out, that sets out reasons for refusing the application.
Sorry, could you just go back to
Yes.
the page before the last one,
So page 15.
please? And then page 16. Yes, thank you.
So if we go on to page 19 again, Shomik. So this sets out the reasons given by the Skipton Fund for refusing an application. The inquiry hasn't...
Sorry, could you just go back again?
Yes, of course.
There's something troubling me about the figures.
Is the maths not adding up?
It's let's have a look at 15 again, if you please. The number declined 845, and then can we go over the page? (622) no appeal, so that leaves 200 and odd. But 443 applications are reviewed by the appeal panel. How does that figure?
Some of the applications were allowed.
Yes, I follow that. But so go back to the previous page.
So 63.2.
Yes, I see. So this is the whole. I follow that the total applications declined is the overall picture.
Yes.
I've got it now.
Yes.
What was troubling me, I think, was the idea that this was looking at the administrator's figures rather than the appeal figure. But I understand now how it fits.
Good.
And just in case my concern was shared by anyone else watching, that's the answer. Thank you.
This table looks at 307 files. So these are all files that fall into that category of the 622 applications declined by the Skipton Fund, where there was no appeal. The inquiry doesn't have the files for all of those. It's obtained 314 of those files, and the 307 of them were sufficiently complete for review. That's why the figure adds up to 307. So these are files that the inquiry has looked at to try and identify from the file what the primary reason was for refusing the application. Sometimes more than one reason is given. But this is what seems to be the primary reason. And we can see there, anti-D immunoglobulin injection, a reason in 12 cases. We'll come back to what is meant by application form, but essentially insufficient information on the application forms led to the application being declined in 2 cases. 68 cases where intravenous drug use was the basis for rejecting the application. And then the largest number, are the next two categories: lack of evidence of NHS transfusion/blood product, medical records destroyed/unavailable, 72 and 76 cases respectively. There's an overlap between the two. The terms are not used as discrete terms of art in the materials that the inquiry's looked at. So this takes the way in which the refusal letters have characterised the reason for the refusal, but in reality those may not be two discrete areas. And then we've got further examples. We can see 27 cases, for example, which are post the screening date, the September 1991 screening date. Some refused on the basis that the transfusion probably took place overseas. 2 on the basis of sexual intercourse being the likely route. 1 on the basis of tattoos. So those are all cases that went no further because there was, for whatever reason, no appeal. If we then go on to page 21, here the inquiry has set out the position in relation to applications that were refused by the fund and did go to appeal, but were also refused on appeal. Slightly different reasons sometimes given. So if we go over the page, this is, again, we've sought to look at the appeal refusal letter to try and work out what the primary reason is. We can see, again, intravenous drug use is a relatively sizable number of cases. And then the biggest category is lack of evidence of NHS transfusion/blood product. A smaller number in the category of medical records destroyed or unavailable, but again, the two effectively interrelate and overlap. And then if we go to...
Just pausing there for a moment. 845 applications were declined altogether. If we go back to the page before this, and again. Oh, sorry, wrong page. It's page 50. What you were telling me, the figures which came out, the breakdown of reasons given before appeal.
Page 19.
Thank you.
This is where there's no appeal.
Yes. That comes to 307.
That's because those not all the files have been provided to the inquiry or are available.
This is because of the Russell Cook problem.
Well, we don't. It may not be a Russell Cook problem. We don't.
Sorry, I didn't mean to imply it was their fault, but it's the problem which has emerged.
The problem that's emerged that we've asked for all files that are where applications have been refused either at the first stage or on appeal, but not all files still exist in what Russell Cook appeared to have been provided with. And again, it's an issue I'm going to want to explore with Mr. Fish tomorrow as to whether there's any reason why that might be the case. But so we've only been able to examine a proportion of the files as a result. And that's why the figures, when we look at the examined files, are lower than the total numbers.
So these figures may change if further files come to light?
Yes. Yes, that's right. So I'm just going to, we've set out in the report from page 25 onwards. We just go to that. I'm not going to go through the detail of all of it. But we've set out our understanding of the categorisations that were used by the Skipton Fund, and the evidence upon which the Skipton Fund relied in relation to certain categories. Issues such as lack of evidence, medical records being destroyed or unavailable, natural clearers are probably fairly self-evident as to what's meant by that. The question of whether the right approach was taken is obviously a different one. But there are two areas where I just want to look at the underlying evidence that the Skipton Fund considered as a matter of generality in relation to certain cohorts of cases. And the first is in relation to the anti-D immunoglobulin injection cases. So if we go, please, Shomik, to SKIP 5031_071. This is a letter, and if we go over the page, it's from Dr. Hewitt of the National Blood Service, who of course was then appointed the following year to the appeal panel. If we go back to the first page, it's a letter dated the 24th of February 2005. And it sets out Dr. Hewitt's view in response to an invitation from the then administrator, Mr. Foster, about the risks of infection transmission from anti-D immunoglobulin. And she says in terms in the second paragraph, anti-D immunoglobulin produced within the UK or either by BPL or SMBTS has an unparalleled safety record. She says no established reports of infection transmission by the intramuscular product produced within the UK since treatment began. And then she contrasts that with there being well-documented transmission episodes from anti-D immunoglobulin preparations produced outside the UK. Examples given that produced by the Irish Blood Transfusion Board and a well-documented episode relating to anti-D immunoglobulin used in Germany. She says those preparations involved a completely different method of manufacture from that used within the UK, and the Irish one was an intravenous rather than intramuscular product. She says she's aware that some Irish anti-D immunoglobulin was imported into the UK and used on a named patient basis on a very small number of women, and suggests that there was a recall and notification exercise in the course of the 1990s. She says towards the bottom of that paragraph, I'm not aware of any UK recipients traced through this process who were found to be infected with hepatitis C as a result of this exercise. It is possible, however, that there may be cases which have only subsequently come to light. I'm not aware that the product used in Germany was ever imported into the UK. And then over the page, she says, in general, therefore, women who've been treated with anti-D immunoglobulin within the UK would have received UK product which is considered safe from the point of view of viral transmission. There may be a few women who receive products manufactured outside the UK, which might have presented a risk of hepatitis C infection. In order to totally exclude this scenario, it would be necessary to know whether there are any reasons to believe that non-UK product was used. This would only have been in exceptional circumstances and not for routine treatment during and after pregnancy. So that was Dr. Hewitt's view expressed to the Skipton Fund, and it would appear from the examination of the applicant files that the inquiry is undertaken that effectively this then formed the basis for the Skipton Fund's rejection of cases where an individual believed that they'd been infected with hepatitis C as a result of receipt of an anti-D immunoglobulin injection. And if time permits, we'll look at a couple of the case summaries in that regard that we've referred to in this note. But it doesn't appear as though, at least as a matter of routine, applicants were provided with a copy of Dr. Hewitt's letter. And so all that applicants in general received was a refusal letter which would state, typically in fairly short terms, that the fund or the appeal panel were satisfied that the product they received was safe in terms of viral transmission. There is evidence to suggest that if an applicant asked to see the basis of the Skipton Fund or appeal panel's view, this might then, after the event, be provided to them. There's only one file that suggests that was the case. But it wasn't routinely shared with applicants so that they could make any submissions or representations or indeed obtain contrary medical evidence or expert opinion about the issue.
Do we know if anyone to whom this reason applied and was given a copy of this information said, well, how do you know it has an unparalleled safety record? Because I believe I'm someone that got it. Have you not taken my case into account? In other words, what's the evidence to show it had an unparalleled safety record, whatever that means?
Well, there is certainly one of the individual cases that we've referred to in our case studies, where and if we, in fact, we can go to page 40 of the note. So if we go back to INQY 40245. INQY 40245. I had it on screen a few minutes ago. Page 40. This is one of the examples of someone whose application was rejected, and we can see the terms of the rejection in paragraph 142. Skipton Funds noted they'd been informed by the National Blood Service that the Immunoglobulin project the applicant had been treated with in 1984 was safe and therefore not a possible route of hepatitis C infection. This advice was not provided to her. And there's actually an email exchange between the fund and Dr. Hewitt, in which Dr. Hewitt expresses, having been asked to, expresses an opinion, and that's not provided to the applicant. She made submissions in support of an appeal, and we've sought to summarise them very briefly in paragraph 143 of the note. And she did, I think, from recollection, query what's the basis upon which you say this is safe? How does one know it was safe? The appeal was unsuccessful, and we can see the terms of the refusal in paragraph 144. Our expert members, who by then included Dr. Hewitt, accepted the universally held opinion that a transfusion with anti-D would have been without any risk of infection with hepatitis C. And there's an assertion that only British anti-D would have been used. There's never been any evidence this product carried any risk of transmitting hepatitis C. Other imported anti-D products are known to have carried such a risk but would not have been used in your case. So that's the approach taken in her individual case, but from what the inquiry has looked at, it's fairly typical of the approach taken by the Skipton Fund to anti-D immunoglobulin injection cases. The second example, it's probably worth mentioning at this stage, if we just go to the bottom of the page, we've got the case reference there. So this is someone whose application was declined, who appealed, and whose appeal was rejected. If we go over the page, pick it up at paragraph 146. Again, we can see the application being declined, the fund stating recent guidance had been obtained from the National Blood Service regarding anti-D immunoglobulin, so that's the letter from Dr. Hewitt. That wasn't provided to the applicant. The applicant appealed. We can see from paragraph 147 she provided a personal statement, and a hepatologist who had supported her appeal thought that her only risk factor for hepatitis C was the injection received. The appeal was refused. She made a second application. If we go down the page, we can see second application failed. That's paragraph 150. And the matter goes to the appeal panel for a second time. And then if we go over the page, we can see she had clinical evidence supporting her application, which we've set out at the top of the page. We can see the GP's view set out in paragraph 152, but then the appeal panel refused it again. This is paragraph 153. I should say, we've said in paragraph 154 that it was unclear how the panel concluded that the anti-D was intramuscular and from BPL. There is a reference to a batch number in the documents that the appeal panel had, although the batch number is given as SD57, not GD57, but in any event. But perhaps most notably is paragraph 155. The applicant supported using the same information, has succeeded in an application to the English Infected Blood Support Scheme. I should, just for the sake of completeness, invite you to note, sir, if we look at SKIP 5031_070, that a further advice or an updating advice was provided in 2010 to the Skipton Fund on the issue of immunoglobulin. And if we go to the third page, we can see this was from Dr. Hewitt again, in conjunction with Dr. Dash from BPL, and essentially it set out the same view as Dr. Hewitt had articulated.
Just go back to the first page of that letter. It says there have been no documented, this is the second sentence, second paragraph, there have been no documented reports of hepatitis C transmission through intramuscular immunoglobulin. Now, assuming for the moment that NTD of British origin is intramuscularly injected, where does the complaint to the Skipton Fund sit as a documented report?
You mean the appeals?
The appeal. Because the appellant is saying, I had this, I got it. In one case, my GP thinks that's a high possibility, is the expression he uses, that it came from NTD. There's no other obvious source.
I anticipate, although this is a question we'll no doubt want to ask Dr. Hewitt herself about, that documented reports probably refers to medical literature, but whether that's the case or not, only Dr. Hewitt or Dr. Dash will be able to confirm, but it may be that that's what they're referring to.
Yes.
Dr. Hewitt herself would have been aware of the applications that were being made and that were coming to the appeal panel because of her involvement with the appeal panel. So that, in any event, that's the updating evidence obtained by the Skipton Fund in July of 2010. So the second category of cases where the Skipton Fund had and relied upon expert evidence is in relation to intravenous drug use. And if we could go, please, to SKIP 5031_217. This is a document provided in response to a request from the Skipton Fund. It's from Dr. Mary Ramsey of the Health Protection Agency, 19th of March 2007. And you'll see what's set out under the introduction is the question we've been asked is whether the panel, which is presumably the appeal panel, can be more precise in its quantification of the chance that injecting drug use for less than 2 years has been the cause of the HCV infection in someone who also has a history of blood transfusion. And then she sets out 3 issues addressed, estimating the risk of acquiring HCV through short-term drug use in the UK, additional factors that may influence the estimates of risk from short-term drug use in the UK, and estimation of the risk of acquiring HCV infection through the receipt of unscreened blood in the UK. I'm not, in the interest of time, going to go through what she says in relation to each of those matters, but if we just go to the summary on page 4, we can see what's said is this. Overall, the risk of hepatitis C infection with short-term injecting in the UK is poorly documented and is likely to have varied geographically and over time. Although data on one-off or casual injectors is absent, evidence from many countries supports the belief that the risk of acquiring hepatitis C in the early period of injecting is high. The estimated probability of transmission from single episodes of needle and syringe sharing also appears to be substantially higher than the risks associated with a single transfusion of unscreened blood. On an individual basis, it will be difficult to assess the risks associated with single episodes of injecting where sharing is denied, but recent studies suggest that the incidence of hepatitis C in injectors who deny sharing is around half of that observed in those who do report such behaviour. So it might be said somewhat equivocal conclusions. I don't mean that necessarily pejoratively, but that's the way in which the summary is expressed. In terms of what we see the Skipton's approach being to IV drug use, well, I can really only say this. The inquiry has not yet viewed or seen any applications where someone who reported intravenous drug use succeeded in their application to the Skipton Fund. So it appears to have been regarded effectively as an exclusionary condition. Again, we'll be asking relevant witnesses this week about more about that. If we then come on to, if we go back to the inquiry's note, Shomik, INQI 40245. And we go to page 32. This is the inquiry's analysis of applications that were declined by the Skipton Fund but overturned on appeal. So you'll see in paragraph 109 there were 220 applications according to the spreadsheet data we've received for stage 1 payments declined by the Skipton Fund, overturned on appeal. The inquiry's got 211 of those files, and 208 are sufficiently complete in order to be able to understand what the basis was of the decision. We can see of these 208 cases, the vast majority of them were refused by the fund, the administrator, because of lack of evidence or destroyed medical records. What's difficult to ascertain from the documentation is how the appeal panel approached the cases and what the basis was for the appeal panel, as it were, overturning the decision. Where the appeal panel was disagreeing with the fund and overturning the decision, its letters communicating its decision really just said that the panel was satisfied that the person was eligible on the balance of probabilities, rather than going to detail about the reasoning. We've, again, set out in the note, I'm not going to go through the details of it, tried to identify cases where we can see what the basis was for the appeal panel's decision. There are certainly some cases in which there's additional evidence, and it may be that that's why the appeal panel had taken a different view. But there are other cases where there hasn't been an additional evidence, but the appeal panel's taken a different view, and it's effectively not been possible to understand from the documents alone why that might have been the case. If we then can go to page 38 of this document. What we've done in this section of the note is just set out some summaries of applications. They're inevitably selective because we haven't sought to summarise the contents of the hundreds of files. But we've tried to select applications which illuminate aspects of the decision-making process to try and get some understanding as to the approach taken either by the fund or the appeal panel, or both. And so there are, I think, some 23 anonymised summaries that we've set out in our note. I've already drawn attention to the two of the cases that were anti-D immunoglobulin injection cases. If we could go, please, next in this document to page 42. you'll see at the bottom of the page, case summaries, lack of evidence. So the majority of the cases that we've referred to in this note are cases which failed, were rejected or declined on the basis that there was insufficient evidence and or medical records destroyed. And there's a theme of the documentation is the difficulties that that's caused applicants in terms of making successful applications. I'm just going to refer to a handful of them in the time available. And to start with case 3 set out paragraph 156 onwards of the note, but I'll do it by reference to the underlying documents if I may. So Shomik, it's SKIP 5079_017. If we go, first of all, to page 12 of this document, so it's not terribly easy to read, but essentially this is the completed application form, and if we look at the bottom half of the page, we can see that the doctor completing this has confirmed infection most probably arose through NHS treatment, the hospital's identified, the procedure is identified. In terms of do any records exist, the answer is unknown. Do you believe infection occurred before the 1st of September 1991? Yes. And then if we look at the right-hand side, other possible sources of infection, the doctor has suggested no in terms of other possible sources of infection. And then the bottom of the page, in your view, is it probable that the infected person's HCV infection was acquired in consequence of NHS treatment received before the 1st of September 1991? Answer, yes. And this was an applicant who believed that the source of his hepatitis C infection was a blood transfusion received in 1986. There were no relevant records, but the applicant was able to provide some medical or some letters from his records, so nothing that directly related to the transfusion itself. But if we go to page 6, please. You'll see here a letter from a surgeon, second paragraph. I note that he has hepatitis C as a result of a blood transfusion when he fractured his ankle. And if we go to the top of that page, you'll see the date of this letter is August 2001. So that's a view being set out at a time when the Skipton Fund did not exist, had not been announced. So it can't possibly be thought that this was somehow some form of contrived state of affairs. And then if we go to page 8, please. Again, one doctor to another, setting out their view in December 2000, so again before the Skipton Fund ever came into existence. First paragraph of the letter, I note he has a history of transfusion-acquired hepatitis C virus. So the view of treating doctors appears to have been it was transfusion-acquired. There were no records relating to the transfusion itself. If we go to page 3, you'll see there it's an unsuccessful application. So this is a letter from Mr. Fish, April 2009. Paragraph 2, it's with regret I must advise you your application has been declined. This is due to the lack of supporting confirmation. So as it were, seems as though it was looking for confirmatory or corroboratory evidence that you were treated with NHS blood or blood products prior to September 1991. On 2 of the letters we've received from 2000 and 2001, it mentions a past transfusion, but in the absence of medical records, this was presumably as a result of consultation between you and your doctor. And then it says, if you do obtain any other supporting medical records, please return these along with your application form. And then, so in answer to a question you asked earlier about the appeal panel, you'll see this is a fairly standard form paragraph in these letters. Mr. Fish refers to the right of appeal, and he says in the last sentence of this letter, I enclose a copy of the appeal panel guidelines for your reference. The evidence the inquiry has in relation to this applicant is that he felt unable to appeal because of his dyslexia, and so his was an unsuccessful application. Shemik, if we go back to INQY 40245, please. And we go to page 43. And I'm not going to take some of these just by reference to the notes rather than going to the underlying document. So case 4, again, is a case in which the applicant believed that their hepatitis C infection was caused by a particular operation, transfusion in 1991. It's before the cut-off date of September 1991. There's no clear evidence in the medical records one way or another, but there's a note that you'll see that we've set out in paragraph 161, declined on the basis of lack of supporting medical records. And then case 5, just go further down the page. This is someone who made an application in May 2016, believed that the source of his hepatitis C infection was a blood transfusion received in the 70s following surgery for a ruptured Achilles tendon as a child when he put his foot through a broken window on a landfill site. We go over the page. You'll see that the application was unsuccessful. That's paragraph 165. And sorry, I should just pick up at the previous paragraph, top of the page. In accordance with the appeal panel guidelines, this applicant obtained confirmation that his medical records had been destroyed, so he couldn't produce any further evidence. If we go to the documents themselves, Shemik, it's SKIP 5044_008. And if we go to what I hope is page 17, yes, so we'll see here the refusal letter, July 2006. We see in paragraph 2 it's due to the lack of supporting medical records. Of course, he couldn't have any medical records because they'd been destroyed. There was a handful of documents that, that the applicant did have, and you'll see reference made to that. No reference to treatment with blood or blood products. This isn't a procedure where a blood transfusion would probably be required. So the application is rejected. Now, this applicant did appeal. If we go to page 11, he put in a letter from his mother, who confirmed that, and this is the last sentence, he lost a lot of blood and had to have a transfusion and an operation and 32 stitches. So his mother said he'd had a transfusion. If we go to 2 pages before that, the applicant himself gave his own account. He refers to, in the first paragraph, last sentence, to the application form and his own consultant confirming her view as to the probable route of infection. Paragraph 2 refers to the destruction of the records. If we go a little further down, we can see paragraph 1, this is numbered paragraph 1, he refers to his accident and the treatment being in 1978, and his consultant, his liver consultant, having said that the damage already caused to his liver was consistent with having the disease for 30 years or more, which would place it as in all likelihood a childhood event. Paragraph 2, he sets out further detail about the circumstances of the accident. He talks about how he had to be carried by a friend, and his leg was bleeding profusely. He had a 3-week stay in hospital, and he refers to his mother providing a statement. And it's also right to note that the person who effectively carried him from the accident site to get help also talks about him having been bleeding badly. That's page 4. Penultimate sentence of the main paragraph there. His leg was bleeding badly, so badly hurt he couldn't walk, etc., etc. And then if we go to the appeal panel's decision, that's page 2. These decision letters are largely in identical form for the most part, apart from 1 or 2 paragraphs. So what's set out on this page appears in almost all of the appeal panel's refusals. First paragraph says, you'll be disappointed to hear the panel's refused your appeal. To help you understand our decision, I'd like to explain to you the clearly defined role and powers of the appeals panel. And then what's set out are a number of paragraphs which are not particularly material to this particular individual case. Bottom of the page, we'll see reference there to the burden on the appellant to satisfy the panel on the basis of balance of probabilities. And then the last sentence says, in order to be satisfied that this is the case, the panel will pay particular attention to the treatment records of the person concerned. And of course, he had none. Next page. This is the next 2 paragraphs are where we get the substance of the decision. We reviewed the entire panel of papers and all the additional information supplied for the appeal. We noted there was no record of any transfusion in your notes. Well, most of the notes aren't there. The panel was including our expert members, was of the view, supported by the clinical records we've seen, that there's insufficient evidence to show you were treated by a blood transfusion. And then there's reference to the severed Achilles tendon, delay in receiving treatment. It said that part of the leg is lacking in blood vessels and the bleeding from it is restricted, so there was little likelihood of your needing a transfusion as a fit 10-year-old. As a result of these considerations, we weren't satisfied. It's probable that the infection resulted from qualifying NHS treatment, and accordingly regret we must refuse your appeal. So you'll see there's no engagement with the actual evidence provided by the appellant, not least from his mother, who's provided a statement saying he received a transfusion. And that's a pattern we see in a number of these cases where there is supporting evidence from either the individual saying, I remember receiving something, or from a family member saying, I remember being told that my brother, husband, father, etc., had received a transfusion, or my wife during childbirth had received a transfusion. The refusals don't engage, for the most part, with that evidence. And don't assist us in understanding what the panel made of it. And so that's an example of a case refused where there was precisely the kind of supporting evidence that the appeal panel guidelines invited applicants to submit to it. If we go back to INQY 40245, please, and we go to page 44, bottom of the page, this is the case, an example of a successful appeal. So we can see from paragraph 168, this was an individual who pointed to surgery they'd received in 1974 and said that they thought that they had a blood transfusion then. If we go over the page, there were records which confirmed the procedure that the applicant underwent, but there were no records of a transfusion as such. The clinicians supporting the application expressed their opinion that the blood transfusion would have been required. The application was, again, refused. The applicant appealed, and this applicant was able to consult and obtain a report from a private clinician, which of course will not be something that many applicants can do. And we'll just look at the documentation in relation to that. It's SKIP 5088. I think, sorry, I've not got a full reference there. Show me. Oh, that's right, SKIP 5088. If we go to, so I hope will be page 31. No, sorry. Let's see. We go on a couple of pages, Shona. Okay, if we go on another 1, 2, 3, 4, 5, 6, 7, go on about another 10 pages. Okay. Next page. No, we'll get there in the end. The problem is that my pagination doesn't match this. Well, I'm just going to read aloud the relevant paragraph. So this applicant obtained a report from a consultant ENT surgeon who expressed the view that it was very highly probable indeed that the applicant would have required at least one or more blood transfusions at or around the time of the operations he described. So we can take that document down. That doesn't help. Sorry. Actually, if we go to page 20, perhaps. So that was the additional evidence, or part of the additional evidence the applicant put in on appeal. And if we can see the appeal panel decision here, if we go to the bottom of the page, we can see it says the panel reviewed the entire panel of papers held by the Skipton Fund and also viewed the additional information. Again, that's a standard form of wording. Go to the next page. As a result of these considerations, we were satisfied it's more likely than not that your infection resulted from qualifying NHS treatment. So that's why I said a few moments ago, so we can't tell from the successful applications how material was considered by the panel, because it's really just a communication of the decision rather than any detailed assessment of the evidence. But this application succeeded on appeal, might be thought probably because this applicant was in a position of getting a private report that he was able to submit to the appeal panel, which will be beyond the abilities of many applicants. Going to give, I think, perhaps just one or possibly two more examples to see how this issue of lack of medical records or lack of supporting evidence affected applications. If we go back to INQY 40245 and go to page 45, so we can see here case 7, bottom half of the page. This was an individual who'd had treatment for a range of injuries, broken nose, broken teeth and blood loss. Most records were unavailable. Paragraph 174, the applicant obtained confirmation that records would have been destroyed in line with the relevant document destruction policy. We can see from paragraph 175 the application was declined by the Skipton Fund. Reference being made to the lack of supporting medical records. The applicant appealed. We can see paragraph 176 reference to the applicant having referred to his mother's diary as evidence he developed jaundice in December 1970, and he was asked to get those pages certified by a solicitor and submitted, which he did. He also supplied school attendance records, which showed that in 1969, the year he stated he was infected with hepatitis C, his school attendance was problematic. But then you'll see in paragraph 172, the panel refused the appeal, asserting that the jaundice suffered in April 1970 couldn't have been connected with a transfusion in August 1969 as the gap in time was too long, and then said it was not clinically plausible that the injury suffered would have necessitated a transfusion. And I'm just going to show you a couple of underlying documents relating to this particular file. It's SKIP 5027_006. If we go to, I think it's page 15, show me. Okay. Yes, so the applicant provided here a fairly detailed account of what had happened to him. Towards the bottom of the page, he refers to significant blood loss. And he says, I know I spent one night and possibly two at the hospital. I also know I lost a lot of blood, and they gave me some to top me up. This had been an injuries sustained on holiday. If we go to page 8, we can see the appeal panel rejected the application. If we go to the second page, paragraph 1 refers to no record of transfusion in the notes. There was little by way of notes. Paragraph 2 is the reference to there being too big a gap in time. So this was something that they apparently accepted he suffered jaundice in April 1970, but asserted it couldn't have been connected with a transfusion in August 69 as the gap in time was too long. If we then go to page 6, the applicant provided further medical evidence in the form of a clinician's opinion. So this was in July 2012. And bottom of the page, last two paragraphs, so the doctor refers to the Skipton appeal panel's reasoning, and then says this: on balance, as an expert in the area of clinical microbiology and as a clinical practitioner, I would have some concerns around these findings. As to whether or not you had a blood transfusion, my view is that it would be difficult to conclude that it was not clinically plausible, given that your injury was severe enough that you had to be hospitalised, and the need for a blood transfusion would have been determined by the amount of blood loss rather than the specific injuries. In addition, significant blood loss associated with facial injuries is well recognised. And then the next page, in terms of the issue of hepatitis C, the accepted incubation period for hepatitis C is up to 26 weeks. However, longer incubation periods are described in the literature, and it is therefore, in my opinion, possible that the jaundice you developed in 1970 could have been due to hepatitis C acquired from a blood transfusion in August 1969, especially given your lack of other risk factors for this condition. So that was submitted to the Skipton Fund, but the appeal panel maintained its refusal, and the appeal was unsuccessful. And we can take that down. So those are just some of the examples from the case summaries we've looked at, or that we've referred to in our written note. Those summaries, in turn, are just some of the examples of applications that were unsuccessful, in particular because of lack of medical records or other contemporaneous clinical documentation demonstrating that a transfusion was undertaken, and would appear to suggest that there were significant hurdles in the way of applicants who were unable to point to actual medical records detailing the transfusion. And so we have further examples that we've set out in the material. And of course, you, sir, in the statements you've read, will have seen still further examples from those who've provided the inquiry with witness accounts. So that's then, I think, completes the Skipton presentation. And then this afternoon, we'll hear from Anne Lloyd.
Very well. Thank you very much. 2 o'clock then. 2 o'clock.